I'll be looking at is AA Nigeria, and this was the Court of Appeal's first attempt at considering the unduly harsh test after HRA Iraq. The judgment is long in the sense that it has so much going on. And so what I've done for everybody is provided the paragraph numbers and the relevant parts that I think will be interesting for everybody going forward. Remember, this is the first decision after HRA Iraq. Now, in terms of how I'm looking to structure this, firstly, how should deportation case law be used by the first-tier tribunal? Some very helpful guidance provided in this case. Secondly, what is meant by unduly harsh under section 117C5? One would think that it's just a rubber stamping of HRA Iraq, but I think that it builds on it somewhat, and it also provides guidance as to how we as practitioners should be approaching this. Thirdly, how to approach the very compelling circumstances assessment under section 117C6, and also what additional factors then take somebody over and above in order to subvert deportation. Fourthly, relevant factors that I've found in this judgment and are cited approvingly in this judgment, which might be relevant for practitioners handling these type of deportations for serious offenders. And lastly, an interesting aspect of this judgment is how much is devoted to rehabilitation and how it builds on what has been said in HRA Iraq. Again, very useful dicta coming from the Lord Justices, all of which were unanimous in their decision. If I can have the next slide, please. So I've provided for you here the relevant legal framework. Everyone should hopefully be aware of this. This is the statutory framework that was considered in this appeal. Specifically, we're looking at section 117C5 and 6. These are the two relevant parts. The 5 is exception 2 and applies where the criminal has a genuine and subsisting relationship with a qualifying partner, or a genuine and subsisting relationship, parental relationship with a qualifying child, and the effect of deportation on the partner and child would be unduly harsh. And then we have the very compelling circumstances test over and above those described in exceptions 1 and 2. And we also have the paragraphs 398 and 399 of the immigration rules, which virtually replicate what is in the statutory material. If I can have the next slide, please. So just to give you some context as to what happened in this case, the appellant was born in Nigeria on the 2nd of January 1988. He arrived in the UK with his mother when he was only just 11 years old. And the background actually for this appellant in particular was focused on by the Court of Appeal, and is somewhat tragic, unfortunately. But aside from that, he had two British citizen children, 12-year-old daughter from a previous relationship, and a 6-year-old son from a relationship that was subsisting at the time, born whilst he was in prison. And at the time of the first-tier tribunal determination, his partner was pregnant with a third child, but that child was obviously not considered in the first-tier tribunal determination. The conviction and sentence which triggered deportation was conspiracy to supply heroin or cocaine, and got 4.5 years. So therefore he was a serious offender and had to surmount very compelling circumstances over and above exception 2. He was released in 2015, and this is a relevant point that I've picked out in the facts, and it will be relevant to rehabilitation, which I'll address later. But he continued to live with his partner and his son and maintained a relationship with his daughter from a previous relationship. Now, it was accepted that it would be unduly harsh to expect the children and partner to accompany him to Nigeria, and that was an important concession running throughout. But however, it was simply whether it would be unduly harsh to begin with for the appellant's partner and children to continue to live in the United Kingdom without him, and then after that, whether there would be very compelling circumstances over and above. After the first-tier tribunal determination, which allowed his appeal, the Secretary of State appealed to the upper tribunal and was actually granted permission to appeal on the basis that there was a potential error of law in the first-tier tribunal's conclusion that there were very compelling circumstances. And the upper tribunal ended up remaking the decision and found that it wasn't open to the first-tier tribunal to find that there were very compelling circumstances without finding that the exception 2 was met. Although, again, something I'd like to point out, it recognized that the judge was entitled to take into account rehabilitation and absence from offending since release. When the upper tribunal remade the decision, finding against the appellant that neither unduly harsh nor very compelling circumstances were met, there's a specific paragraph that is actually quoted in the judgment, and I'll be coming back to this, but it's worth mentioning it now, their separation from their separation, the children partner, from the appellant will undoubtedly be harsh. It may even be very harsh. However, the factors relied upon are no more than those which would be involved for any child faced with deportation of a parent. I do not accept that the evidence shows that they are very high, that the very high threshold which applies here is met. We'll come back to that, but that's a very important way of trying to interpret the unduly harsh test by categorizing it, and the Court of Appeal weren't too happy with that. Could I have the next slide, please? So I mentioned that there was some very useful guidance given to practitioners and the first-year tribunal. The first of which was there's only 4 authorities which should be expected to be relied upon going forward. And I think this is probably because, as the Court of Appeal probably has encountered on many occasions, as we all would have encountered on many occasions, there's been a proliferation of case law regarding unduly harsh and the very compelling circumstances test. And so what the Court of Appeal has said is that it usually be unnecessary to refer to anything outside of the 4 authorities. And these were KO Nigeria, Bindloss, Kiari and Bindloss, NA Pakistan, which is relied upon quite heavily in this judgment, and HRA Iraq, which Zainul has taken us through. Secondly, they said that what won't be helpful for the first-year tribunal is to provide them with other examples of other cases and try to contrast and draw factual comparisons between similarities or differences. And this is largely drawing on the judgment of HRA Iraq, which says that this is an individual, personalized assessment that should be carried out. So you can see the sense in trying to make further guidance on this clear for practitioners and the tribunal. Thirdly, the decisions should involve a close focus on the particular individual and those circumstances, and require a close focus on the particular individual's private and family lives in question, judged cumulatively on their own terms. Again, trying to reinforce the same point that this is meant to be focused on the appellants themselves. And lastly, which I was very interested to see, that judges who are experienced in these specialized courts should be assumed by any appellant, court or tribunal to be well familiar with the principles and to be applying them without the need for extensive citation, unless it is clear from what they say that they have not done so. It's interesting to see this in there, simply because there has been so much case law to this point and so much has been referred to in tribunal hearings. Perhaps maybe this is trying to refine the art and make it a lot simpler for judges and for also practitioners moving forward, dealing with deportation. Could I have the next slide, please? Right, okay, so what does the Court of Appeal in A, Nigeria say about the unduly harsh test? Specifically, how do KO Nigeria and HRA Iraq together? Well, it actually says that the former, at paragraph 10 of this judgment, the former, KO Nigeria, addressed the issue notwithstanding that the main question in that case was not the meaning of unduly harsh, but whether it involved consideration of the seriousness of the offense. So we know what KO Nigeria is dealing with. However, what they say about HRA Iraq at paragraph 35 of this judgment is that it is a necessary adjunct to KO Nigeria, both because it explains aspects of Lord Conworth's observations and because it provides additional guidance to the application of the unduly harsh test. So additional guidance, so both have to be read somewhat together, one would think, from this judgment. But again, you're seeing the Court of Appeal rubber stamp how one should now approach deportation, especially in light of HRA Iraq. Could I have the next slide, please? And I just wanted to point out some extracts from HRA Iraq that were relied upon that, again, rubber stamped and quoted here. This does not posit some objectively measurable standard of harshness which is acceptable. There is a more elevated than merely undesirable, but not as high as very compelling circumstances. And that going beyond that would be of limited value. This is at paragraph 12 of A, Nigeria, in case anyone wants to make reference to this. They also go on to say that it is potentially misleading, and this was interesting to see, dangerous, to seek to identify some ordinary level of harshness as an acceptable level by reference to what may be commonly encountered circumstances. And again, I thought this is an important point. There is no reason in principle why cases of undue harshness might not occur quite commonly, and how a child will be affected by a parent's deportation will depend on almost an infinitely variable range of circumstances, there's no need to look for a baseline of ordinariness. Now, unfortunately, in the case of A in Nigeria, when it was before the upper tribunal, that is exactly what happened. The upper tribunal's decision in this case actually specified a category of very harsh, as I mentioned earlier, rather than whether it would or would not be unduly harsh. And Lord Justice Popwell added that the tribunal judges should just simply refrain from expressing their decisions by categorization or by degrees of harshness, as it simply complicates what should be, as he says, a single and straightforward statutory test. He goes on to say that it's simply undesirable to approach the issue by trying to identify the norm and what the individual goes through beyond that. Almost all cases are different, he emphasizes again, involving a multitude of individual factors, and it is impossible to measure objectively a norm or baseline, again, trying to reinforce the point that the approach should be on the individual themselves. And so, simply put, what should tribunal judges be doing, and what should we as practitioners be looking to do from this guidance? Well, simply identify the factors which are relied on as making the consequences of deportation unduly harsh, and asking for those to be evaluated cumulatively as surmounting either whether it is unduly harsh or whether they are very compelling circumstances over and above. And I thought this was a very important part of this judgment to focus on. Can I have the next slide, please? Right, so after having dealt with whether it would be unduly harsh and how that operates now, the Court of Appeal then goes on to consider the approach of the assessment of very compelling circumstances. I'm sure most of us will be quite familiar with the approach, but I thought nonetheless it's important to just run through this very quickly. They rely and adopt the approach in NA Pakistan, and I've cited the relevant paragraphs that are there in NA Pakistan that are relied upon. And effectively, they say that if the appellant can point to factors identified in the descriptions of exceptions 1 and 2 of an especially compelling kind in support of an Article 8 claim, going well beyond what would be necessary to make out a bare case of the kind described in exceptions 1 and 2, they could in principle constitute very compelling circumstances over and above those described in exceptions 1 and 2, whether taken by themselves or in conjunction with other factors. So again, simply you go through exceptions 1 and 2 first, and then try and see whether the factors are enough to also show very compelling circumstances. There is no exceptionality required. It follows from the statutory scheme that cases in which circumstances are sufficiently compelling to outweigh the public interest in deportation will be rare. Again, this is an interesting point to see this cited, especially with the new interpretation given to unduly harsh with HRA Iraq. And lastly, and this is probably why they were citing as commonly rare, if you are citing incidents of family life, such as simply aging parents in poor health, or just the natural love between parents and children, it just won't be sufficient. You need to take it further than that. And I think that's why they are potentially saying that it will be rare. Can I have the next slide, please? And they also went on to say, they rely on these paragraphs out of NA Pakistan, and I've cited these ones for you as well, in relation to a serious offender. So now, how are we working for very compelling circumstances? It will often be sensible to first see whether his case involves circumstances of the kind described in section 1 and 2, exceptions 1 and 2. So there you go through exceptions 1 and 2 first. Both because the circumstances so described set out particularly significant factors bearing upon respect of private life and family life, and because that may provide a helpful basis, not a basis or the basis, but a helpful basis on which an assessment can be made whether they are very compelling circumstances over and above. And they go on to say that it will then be necessary to look and see, or to see whether any of the factors falling within exceptions 1 and 2 are of such a force, whether by themselves or taken in conjunction with any other relevant factor not covered by exceptions 1 and 2 to satisfy the test. And I will demonstrate to you in this particular case what other factors were taken into account over and above what was demonstrated as being unduly harsh for the children. And I think this is an important, it's very important to see how this operates in practice. Could I have the next slide, please? So first of all, dealing with what factors came into consideration when considering whether it would be unduly harsh to expect the children and partner to to remain in the UK without him. There was a lot going on actually in this case. First of all, the daughter, who was 12 years old, was at a key stage of her physical and educational development as she moved into adolescence. The absence of the father has an adverse impact on the sexual and educational development of girls at this age. This is just a general observation. It's not specific to this girl in particular. It's a general fact that the court is relying on and positively rubber stamping, in my opinion. The daughter had been particularly adversely affected by her father's absence whilst he was in prison. And in this case, she had become withdrawn and struggled with her studies, whereas previously she had been confident as a child, and it was described as having excellent self-esteem, as recorded in the independent social worker reports. So this is an important point. And I think these points can be used just in general for practitioners to almost use as a tick box exercise to see whether an appellant and a relevant child, is being impacted in this way. Fourthly, the absence of the appellant would have a negative impact on the socio-emotional development of the appellant's son. And in this case, he became the primary carer and allowed the partner to work full time. And it was felt that the effect of separation from him would adversely affect the child, the son in particular. And this is a particularly important point. And again, you can see this, that all of the relevant factors are actually quoted in AA Nigeria. If I can move on to the next slide. Now, I'm going to take some time to actually explain some of these because there's a lot going on. It's not simply the fact that these exist, that's enough. It's clear that the individual factors and how it actually affects the appellants is important, or the children, sorry. So first of all, the appellant's absence would have had an adverse impact on the relationship between the two half-siblings. In this case, the children spent time together with the appellant. However, the respective partners, or the mothers, did not have any sort of relationship. And so it was seen that they wouldn't in the future, in the absence of this appellant, put any efforts to bringing these two children together. And so they would have been damage to this family. And this was an important factor that the tribunal and the Court of Appeal thought should have been considered, and duly was. Secondly, the appellant's absence would have a significant impact on the partner's ability to continue to work. Again, because he was the primary carer, it allowed her to work full time. Thirdly, the appellant's absence would have an adverse impact on his son as a result of his contribution to his learning. Again, specifically in relation to this son, he was suspected of having autism spectrum disorder. However, and interestingly enough, the outcome of the test for autism spectrum disorder wasn't actually before the first-year tribunal judge. However, the Court of Appeal found that it's actually open to him to make these sorts of these findings, in spite of there not being independent evidence. And what they go on to say is that at least some special educational needs, drawing from this inference from his attendance at specialist learning center, which supported the children with suspected or diagnosed special educational needs, was enough to support the first-year tribunal judge's assessment. And this, I think, shows a sort of a new path going forward in terms of allowing a little bit more flexibility for appellants where they're unable to bring all the necessary evidence before the tribunal. As we're all aware, legal aid isn't available, so some appellants, unfortunately, have their hands tied behind their backs. And this approach, I think, is actually quite good. Then if we have a look at 4, the partner's medical condition caused her to suffer physical symptoms which could be debilitating and affect her ability to care for her son and the new baby when it arrived. Now, in particular, she had irritable bowel syndrome, and that was seen as being enough. There were other factors as well, apparently, that aren't cited in the judgment that were open to the judge to make his findings, that there would be adverse impact on her. And lastly, the appellant's absence would have an adverse impact on his partner's emotional stability. And in this case, she was exhibiting low moods. Again, there was some form of, from what I understand from the judgment, depression was cited, but there wasn't really any evidence of this. However, again, there was a flexible approach taken and the findings were supported in the round. And it seems like the Court of Appeal were perfectly happy with this. So these are the factors in this particular case that warranted the unduly harsh test as having been met in terms of them remaining in the UK without him. However, what additional factors were taken into account to take this into the very compelling circumstances over and above. And this is the next slide, please. So the additional features, these ones are, it's very interesting. First of all, the abandonment by his mother in childhood, as well as the physical abuse from his uncle and the sexual abuse by the football coach had a huge impact on him. And this is something that the first-year tribunal acknowledged. Additionally, and number two, the appellant would most likely not reoffend, taking into account, first of all, his own evidence about offending and rehabilitation given at the first-year tribunal. Secondly, the circumstances of offending were contrasted against the very different circumstances that he had now, a stable family life. Thirdly, the vulnerability at the time of the offense. There were particular vulnerabilities for this appellant. And lastly, the conduct in prison, but also following release, demonstrated a desire to address his offending behavior, obtain skills that he could use in the community as well. And I thought this was very important to focus on. It's not something that I believe many practitioners particularly focus on, because it tends to be on just what the impact of the children will be or on the partner, and then showing that this is over and above. However, if we are to look and focus on rehabilitation, you can see, and also the individual circumstances when they had committed the crime and what they are now, it's important to contrast these. And the Court of Appeal looked at this quite positively and sought and relied on these as additional features, which then took him over and above. And they ultimately concluded that the exception, section 117 C6 was satisfied. And so I thought, having now focused on the additional factors and the importance that was placed on this, it's probably worthwhile to look and see what the Court of Appeal in AA Nigeria said about rehabilitation. If I could have the next slide, please. So just as a reminder, the first-year tribunal found that it was most unlikely that the appellant would reoffend in the future. Secondly, this was based in part on the appellant's own evidence given at the first-year tribunal about his offending and rehabilitation. And thirdly, his conduct not only in prison, but also following release demonstrated a desire to address his offending behavior and obtain skills he could use in the community in order to reduce the risk of reoffending. So those effectively form the background here as to what the first-year tribunal found. Can I have the next slide, please? Right, so how did the Secretary of State approach the question of rehabilitation? Well, initially, she said and argued that rehabilitation can never be a factor of significant weight in considering very compelling circumstances. And the Court of Appeal actually relied on what was said in HRA, and they say, and this is a bullet point 2 at paragraph 39 of AA Nigeria, the issue has now been fully addressed in HRA at the following paragraphs, where the previous authorities are analyzed. Tribunals will properly remain cautious about their ability to make findings on the risk of reoffending. But, and this is important, where a tribunal is able to make an assessment that the foreign criminal is unlikely to reoffend, that is a factor which can carry some weight in the balance when considering very compelling circumstances, although not one which will carry great weight on its own. So it is possible, if the tribunal has enough before it, for it to actually make that assessment as to whether they are likely or unlikely to reoffend in the future. And again, they do make the point and stress the point that great weight cannot simply be attached to this on its own. There have to be other factors around it. If I could have the next slide, please. Well, the Court of Appeal went on to address the submissions made by the Secretary of State. They say that the Secretary of State's submissions mischaracterized rehabilitation as merely the absence of further offending. Rehabilitation is not limited to the mere fact that there has been no further offending. What is also relevant is the risk of further offending. The fact that the criminal has not reoffended may inform that assessment, but may not of itself provide much of any basis for concluding that the risk of reoffending is significantly reduced, especially if it is for a relatively short period. So the period of time, remember, in this case was 2015, when he was first released from prison, but he spent enough time outside for that assessment to take place. The Court of Appeal went on to say that, however, rehabilitation in the sense of a reduced risk of reoffending is to be assessed by references to a multitude of factors. So what are those multitude of factors? It is a common task for probation services daily to make an assessment in the preparation of pre-sentence reports for sentencing judges, and they perform that assessment by reference to factors, some of which are specific to the offense, but many of which are specific to the offender. So reliance on probation service and their reports, OASIS reports, which I'm aware is mostly recorded and provided either by the respondent or by the appellant. But it just goes to show that it actually carries quite a lot of weight in assessing the future risk of reoffending, not simply whether there is a current risk. If I could have the next slide, please. Okay, so lastly, one thing that I thought was worthwhile pointing out for you is what other circumstances would be taken into account. Well, they say a change of personal circumstances since the offending is capable of reducing the risk of further offending and may in some cases be of sufficient weight to render it unlikely. So personal circumstances. Secondly, it does not need to be specialist experience of probation officers to reach such a conclusion, which may be apparent to an immigration judge depending on the particular personal circumstances in which the offender came to offend, again, looking at what happened in the past, how influenced they were on the offending and how the change of their circumstances affect or the risk of further offending. And lastly, there's a nice summary given at paragraph 40, the vulnerable circumstances in which they offended, the positive steps taken to reduce the risk of reoffending, more stable family circumstances in later years. But they also stress that, but taken with the appellant's own evidence as to his current attitude to his offending, they can properly support the judge's conclusion that the risk of reoffending was reduced to the level of most unlikely. And I think that this is, again, a very important point to stress and focus on in deportation appeals, or maybe even judicial reviews going forward. It can be an important feature as well for just general submissions against a letter from the Secretary of State, making it clear that she is looking to make a deportation order in the future.